Hello viewers, today's topic anticipatory bail, and when I accuse one to one for pre anticipatory bail before High Court divisions. Actually, before arresting the accused by police officer, any person who is implicating in the case but not arrested by police, because anticipatory bail means before arresting a person who is the accused of the case, and he appointed the lawyer, and bail applications submit before High Court divisions by his or her appointed lawyer. This is the anticipatory bail, and it is mentions under sections 498 CRPC, the Code of the Criminal Procedure 1898, because when the laws or filing, actually laws in Thana, GR case, filing CR case before magistrate, but he was or she was not arrested, and she or he is honorable person in the society, falsely implicated his or her name in the Ejhar or FIR, then there is the chance to apply for anticipatory bail before High Court divisions, because this is the discretions of the court, or the honorable court has best power in the all matters, and be to grant the anticipatory bail applying or applicable by accused, which is the allegations, bringing allegations against the accused or that person. Based based opportunity or score, it is the more options on behalf of the accused, because he is not arrested and bringing the allegations against him. An anticipatory bail is applicable before High Court divisions and Honorable High Court divisions when granted the bail as flows of the anticipatory bail. Number one, he was convicted in the respect of the cognizable offense. Number two, after bail, there is no chance to tamper or mental torture the witness or destroy the witness of the case. Number three, there is no options to flee from justice, because when granted the bail of the accused petitioners, actually accused petitioners' applications as a anticipatory bail when submitted before the court decide that there is the more options when to identify clearly there is no chance by the accused petitioners destroy or tampering the witness of the case. I hope that my lecture will be clear, and thank you very much who are joining the live sessions, and always support me and to appreciate my lecture and listening and watching me. Thank you very much. This is the great opportunity from you and only for me. And I am so happy and be connected with you, and you are all persons supporting me and to comments in your comment box to change or to clear about my thought of my lecture. I hope that I always request to all my viewers, if you any questions and mentions in your comments, and I hope that seeing your comments to clear clearly mentions or answer, giving answer to solve the problem. I hope that, and there is no options to delay about this. Actually, anticipative bail with example it will be very clear. Number one, he was renowned person and he was most popular in the society, but some to realize and who is being good in future to destroy the future of him and falsely implicated his name in the case. And when he was implicated or his name is implicated in the case but not arrested by police, when he came to High Court divisions, pay for anticipative bail. And Honorable High Court divisions, for the purpose of granting of the anticipative bail, have to mention about that he is innocent or falsely implicated his name in the case and there is no specific allegations against him. Number two, his name not mentioned in FIR, but allegations it will be find out not specific. Number three, after getting the bail, anticipated bail, there is no options to torture or tampering the witness or destroy the witness of the case, which is very essential to identify the guilty person of the with the alleged crime. Number three, identified that the person previously convicted in the respect of cognizable offense in the court or in a court. Number three, when the granting bail, there is more options. If he fall down or misbehave with the witness, there is chance to arrest by the police officer. And this is the lecture about anticipated bail under section 498, the Code of the Criminal Procedure 1898. No inflexible guidelines and straitjacket formula can be provided for grant or refusal of the anticipated bail because of circumstance and situations of futures cannot be clear visualized for the grant or refusal intrusive bill. In consonance with legislative intentions, the grant or refusal intrusive bill should necessarily depend on the facts and circumstances of each case. Actually, basis on the circumstantial evidence, it will be provided that and finding easily find out being guilty the person for the purpose of the crime, and the court concerned that having no chance to identify and specific allegations is proved by witness, it will be very difficult. And no inflexible guidelines and straight jacket can be provided when the court granting the bail of the accused and allegations by the prosecutions which is not very strong against the accused. The court or high court divisions maintain or granting the bail, anticipatory bail on behalf of the accused petitioner, because accused petitioners getting the bail and allegations of the case, it will be clearly maintained and not harmful by granting the bail of the accused. And accused has liability to give the surety about his bail, anticipatory bail, and after granting the bail of the accused, there is no options destroying the vital witness of the accused, which is very necessarily submitted before the court, and on the basis of the circumstantial evidence and prove that, and being guilty the person who is accused or implicated his name in the case, and complainant never chance and harmful getting the justice before the court after granting the bail of the accused. I hope that my lecture, it will be helpful for you or for your career. And I am Advocate Sharul Kumar Rai, Supreme Court Bangladesh, and founder and director of Sharul Law Academy. My lecture will be the law students or advocate who are practicing in lower court as a criminal trial lawyer or practicing in high court divisions for the purpose of the criminal case, convictions, bail matter, and any other criminal cases. I hope that my lecture be connected with you as a assistant. The nature of gravity of the accusations and exact role of the accused must be properly comprehended before arrest is made. Another, the antecedents of the applicant, including the facts as to where the accused has previously undergone imprisonment on convictions by a court in respect of cognizable offence. Another, the possibility of the applicant to flee from justice. Another, the possibility of the accused likely to repeat similar or other offence. Repeated the similar offence when granted the bail of the accused, for as a result the complainant very harmful for that, and with careful and sincerely when the honorable court granting the bail of the accused have to maintain and there is no options to torture or no repeat similar offence or other offence, because act done by the person who are accused of the case and before honorable high court divisions granted the bail of the accused, and after getting the bail, anticipated bail, the accused persons and repeat offence, similar offence, and it will be day by day increasing, and this is the harmful in the society, and complainant will be harmful for that or being granting the accused as anticipated bail before honorable high court division. Where the accusations have been made only the other of where the accusations have been made only with the object of injuring or humiliating the applicant by arresting him or her. Accused, he will be male or female, doesn't matter, but accepted the accused petitioner as a of anticipated bail with conditions as flowing that with conditions granted the bail, because after anticipated bail and doing act as similar offence and violations the bail or rule of the bail, this is the harmful for complainant. When considering the prayer for grant of anticipated bail, a balance has to be struck between two factors, namely, no prejudice should be a cause to free, fair, and full investigations, and there should be prevent or harassment, humiliations and unjustified detentions of the accused. Granting bail or anticipated bail, because we are going to discuss about anticipated bail. It is the temporary free with conditions and out of jail custody or judicial custody. Granting anticipated bail means it is not freedom long time, this is temporary free and with conditions. If the violations of the bail, police can arrest him. Number one, try to destroy the witness of the evidence and try to torture the witness of the case, or there is chance or he prepare to flee from justice in abroad from our country or Bangladesh, and with conditions granted bail but violations the conditions when the granting the bail, and after violations the conditions of the bail, then it will be cancelled the bail, there is the more chance. So after getting the bail, sincerely the accused have to maintain and balance rule and order with the conditions by the court. This is the today's lecture about anticipated bail, and it will be applicable before our High Court divisions, because regular bail after arrest and anticipated bail before arrest, there is a chance to arrest the person by police. He is not involved, falsely implicated his name in FIR, and there is chance to get the bail before High Court divisions. There is no requirement that the accused must make out a special case for the exercise of the power to grant anticipated bail, virtually reduce the salutary power of conferred by the sections 498 the Code of Criminal Procedure 1898. A person seeking anticipated bail is still a free man entitled to the presumption of innocence. He is willing to submit his restraint and conditions on his freedom by the acceptance of conditions which the court may deem fit to impose, the considerations of the assurance that it arrest he shall be enlarged on bail. Actually, by acceptance of conditions which the court may deem fit to impose, and in considerations of his assurance, and if arrest, he shall be enlarged on bail. Acceptance of conditions, it will be submit before the court and sometimes or some days there is chance to arrest by police, and he came here for anticipated bail before High Court divisions, and when he free getting the bail, he could not flee from justice and not violations the conditions of the bail. And this is the main fact or law point of the fact of the case, because submitted or applications, it will be submitted before the court for anticipated bail, in which of anticipated bail the court identified that the conditions for granting the anticipated bail of the accused. Number 1, he could not fly from justice. Number 2, no violations of conditions when the granted the bail. Number 3, he could not destroy the witness or not torture the witness or not destroy the evidence. Number 3, by the accused not torture or fear to the complainant, and granting the bail there is no chance to harmful or being harmful on behalf of the prosecution or complainant. And I am going to discuss about 498, the Code of Criminal Procedure, anticipated bail before High Court division. I hope that my lecture will be clear and it is helpful for you, and to secure your life and your family or friends, share my lecture or my videos and like and comments in your comment box if you have any questions to share, or send in comments or written in comments box. I hope that submitting my answer to solve your problem. A person seeking anticipated bail is still a free man entitled to the presumptions of innocence. He is willing to submit restraint and conditions on his. The proper course of actions ought to be that after evaluating the averments and accusations available on the record, if the court is inclined to grant anticipated bail, then an interim bail be granted and notice be issued to the public prosecutor. After hearing the public prosecutor, the court may either reject the bail applications to confirm initial order by granting bail. The court would certainly be entitled to impose conditions for granting of bail. The public prosecutor or the complainant would be at liberty to move the same court for cancellations or modifying the conditions of bail any time if liberty granted the course is misused. Number 1, granting bail on behalf of the accused prisoner. and after granting bail, the accused free is free getting the anticipated bail before Honorable High Court divisions if the violations of the conditions misuse the bail, public prosecutor or prosecution or complainant came to Honorable Court for cancellations of bail because the accused is misused. The accused misused the anticipated bail and violations the conditions of the bail, and complainant or public prosecutor had chance to cancel the bail as applications will be submitted before Honorable Court. This is the lecture about anticipatory bail, section 498 of the Code of Criminal Procedure 1898. I hope that my lecture will be clear, and next time, next topic that will be helpful for you and to secure your life and your family, and you are citizen in Bangladesh and know about law, and if you implicated your name in FIR and how to get the anticipated bail before arresting by police, and be careful and sincerely and choosing your friend or company to stay with you with any other person who are competent or not, and to maintain or keep distance with your friends, knowing about him, then making friendship with him or her. Otherwise, you will fall in problem or your name written in a FIR because unknown person act done or doing offense you don't know, but you are always stay with or, and as a known person your name added or implicated in the FIR of the case. So be careful. My lecture will be helpful for you, for your family, to secure your life and your family, to give the safety. Your family have to know about knowledge, about law, and my lecture cover your gap of knowledge for the purpose of legal thought. So this lecture share, and if you any questions, comment in your comment box. Thank you very much. Next time I will meet with you with another topic. I hope that the topic will be sensitive and very helpful for your life and for your family. Thank you very much. Good night, and thank you to everyone and to all my brothers and sisters and seniors and my juniors and my colleagues who are connected with me. Thank you very much, and I need your support, and with your support I hope that do better in my life. Thank you very much. Namaskar.